Good afternoon, everyone. Thank you for joining us for today's online talk, which will start now. For those of you who are here early, thank you for waiting patiently. While you are waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with a vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Business Defamation and Social Media. My name is Rachel Ng. I'm a pupil in Chambers with Ma Wing Kwai and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by our Datuk Ma Wing Kwai. Our able team today comprises of 23 lawyers and a support team of 19. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small-medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, a dedicated employee and industrial relations team, as well as a department focused on servicing the needs of individuals and families. Our practice groups, as you can see from the slide, indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolutions team. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is our 16th talk in 2021 for our online talk series, which has been attended by some 3,000 attendees. Today, we're expecting 145 people who have registered. Please visit our website at mahwingkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation, details of which will be given at the end of this talk. Today, we have two speakers, Mr. Chong Chieh and Mr. Eric To. Mr. Gan will be speaking first, followed by Mr. Eric To. We will then conclude today's session by addressing the questions raised. To all the participants, kindly post your questions in the Q&A box below. Allow me to introduce our speakers from today. Mr. Gan is a partner in our firm in the Dispute Resolution Department. His main areas of practice includes general litigation, will writing, probate and administration, contentious probate litigation, banking litigation, debt recovery, arbitration, construction, family law, criminal law, and management, corporation, and joint management body disputes. Our second speaker would be Mr. Eric To. Eric is an associate in our dispute resolution and individuals and families team. His areas of practice include general litigation, family, citizenship, adoption, land disputes, and defamation. Our speakers will target to complete their presentation by 3:45 p.m. and then they will address the questions posted in the Q&A box. Today's talk points are as follows: what defamation is, justification and fair comment, cases of defamation online, and tips and how to respond. Mr. Gan will be covering point 1 and 2. Thereafter, Mr. Eric will take over to discuss points 3 and 4. I will now hand the virtual floor over to you, Gan. Gan, over to you.
Yes, thank you. Thank you, Rachel, for the warm introduction. And thank you, everyone, for all the participants for taking up some time to attend to today's talk on business defamation and social media. I hope the talk will be helpful. So let me just share screen. All right, I will start my talk on what defamation is. So defamation historically is a common law creature where it was not codified. Mainly are based on cases and it derives from English cases. But in Malaysia, we have the Defamation Act of 1957. Hence, the defamation in Malaysia is governed under the Defamation Act of 1957. There are two types of defamation. One is libel and one is slander. So for libel, it's defamation in permanent form, example, written words in articles, newspaper, Facebook posts, WhatsApp messages, Google reviews, or some other reviews you can find online. Whereas for slander, it's defamation in temporary form, example, spoken words. So a defamatory statement is a statement that tends to lower a person in the estimation of right-thinking members of society in general, causes a person to be shunned or avoided, or to expose him to hatred, contempt, or ridicule, or conveys an imputation on a person disparaging or injurious to his office, profession, calling, trade, or business. All in all, a defamatory statement basically brings you bad reputation. People think badly about you. Hence, a very general idea of that's what it's all about, a defamatory statement. What about libel elements? So here, there is a defamatory statement made or conveyed by written or printed words or in some other permanent form. The defamatory statement concerns the plaintiff, and the defamatory statement is published to a person other than the plaintiff. So in this case, a defamation can only take place if it's published to a third party. So hence, for example, if let's say I want to say something bad about A, and I speak directly to A without any third party being present, that statement is not defamatory. So example here would be, Shop's X food is tasteless and its employees are rude and obnoxious. So this, you have, let's say example is in Google review. So there's these libel elements there. Next, we will discuss the case of Pergom, Nagara, Malaysia against mkini.com Segram Berhad. It's a 2021 case decided by the federal court. Even though this case doesn't relate to defamation, it's on contempt proceedings, but the principles that was set out in the federal court in respect of publication is equally important to be applied in a defamatory situation. So in this case, the Attorney General brought contempt proceedings against Malaysia Kini as a first respondent and its editor-in-chief, Stephen Gan. And I'm quite aware that most people will have heard of this case. It was quite popularly publicized. So in Malaysia, Kini allowed for the publication of comments by third-party online subscribers in response to some online news articles. So these online subscribers basically made comments in the Malaysian Kini, the comment section, and basically allege or scandalize the judiciary, or basically bring the judiciary into disrepute in general, and in particularly comments. There was also a comment made on the Chief Justice of the Federal Court. So in this case, the Federal Court considered Section 114A of the Evidence Act. So what is exactly Section 114A? So here it states that a person whose name, photograph, or pseudonym appears on any publication depicting himself as the owner, host, administrator, editor, or sub-editor, or who is in any manner facilitates to publish or republish the publication is presumed to have published or republished the contents of the publication unless the contrary is proved. Hence, what basically Section 114A states that there is a presumption that if you publish the materials or the defamatory materials or whatever materials on an online on a website, if you are the host or the administrator, then technically it's presumed that you are the person that actually published it. So here in paragraph 45 of the judgment, the Federal Court said that the presumption may be invoked against any person whose name appears on the publication as either the owner, host, administrator, editor, or sub-editor. It is beyond argument that Malaysia Kini, as the first respondent, depicted itself as the host to the publication, and by virtue of Section 114A, Malaysia Kini is presumed to have published the impugned comments. Hence, the comments made by the third-party online subscribers. So whether can the presumption be rebutted? Yes, it can, but in this case, in the Malaysia Kini case, it was not rebutted because paragraph 74 of the Federal Court decision, in our view, to avoid liability, the first respondent must have in place a system that is capable of detecting and rapidly remove offensive comments. The first respondent cannot such wait to be altered because such alert will never come. Such a system, if in place, will go a long way in deflecting any allegation that publishers, like the first respondent, have a guilty mind in posting the impugned comments. It is not enough for the first respondent to merely rely on its T&C to online subscribers, or to say that it cannot edit a comment once it's posted, or that they cannot monitor every comment published. Hence, the burden is very high on the Malaysia Kini to basically say that if they know that such offensive comments will take place, hence they need to have a system in place that is capable of detecting such comments and alert basically Malaysia Kini or the editor to actually quickly remove it. Hence, they cannot just rely on their T&Cs and say that, oh, I cannot edit and stuff. So the three safeguards adopted by the first respondent, which is Kini, have proved to fail and do not efficiently control or prevent offensive comments from being published. The first respondent's responsibility cannot end by putting in place a T&C with such self-serving caveat for its own protection without regard to injury to others. Hence, the surrounding circumstances of the present case strongly suggest that the impugned comments were published without reservation and were only taken down upon being made aware by the police. Hence, here the Federal Court is of the opinion that as an online publisher, you have to do things, or basically you have the safeguards to make sure everything is in place and not just rely on some T&Cs to basically protect yourself. You need to have a device that can actually capture such impugned comments or some unsavory comments from being published. So here the court ultimately held that Malaysia Kini is the owner of its website, publish articles of public importance, allow subscribers to post comments to generate discussions. It designs its online platform for such purpose and decides to filter foul words and rely on the three measures it has taken. In other words, the first respondent designs and controls its online platform in the way it chooses. It has full control of what is published and is not. It must carry with it the risks that follow from allowing the platform operates. Hence, in this case, the Federal Court finds that the presumption was not rebutted. And in the Malaysia Kini case, I think as everyone or most of the participants may aware, the company was fined 500,000 and the editor was let off. Next, on the defense, so let's say there is a defamatory remarks made. So the plaintiff may file a defamation claim. So what are the defenses that defendant can rely? So one of it is justification. To rely on this defense, a defendant has to show that the defamatory words are true or substantially true. So Section 8 of the Defamation Act says that In an action for libel or slander in respect of words containing two or more distinct charges against the plaintiff, a defense of justification shall not fail by reason only that the truth of every charge is not proved if the words not proved to be true do not materially injure the plaintiff's reputation, having regard to the truth of the remaining charges. Yes, I do know that this is very wordy and very mouthful, so I just will try to dissect and to make it simple for everyone's understanding. So basically, it states that if I give an example of an article, of a so-called alleged defamatory article, so maybe a certain portions of the article may be defamatory, but the remainder of the articles are not defamatory. So what Section 8 basically says that if we were to read, or a judge were to read everything, reading the article as a whole, so even though there are statements or portions that may be defamatory or may be untrue, if reading it as a whole, it's not defamatory of the plaintiff. So I give another example which hopefully is relevant and it's easier to understand. So let's say, for example, I make a remark, or I make statements against a teacher, of saying that this teacher is very hard on the students and always beat the students up. So on the face of it, it looks like it's defamatory. But in my subsequent statements, maybe I have said that even though he's hard on his students, but on weekends, he provides free tuition for these students because they want the students to be good in their grades. Hence why the teacher has been hard on the students. Basically, the teacher wants to do something good and raise these kids well. Hence, if reading the whole statements that I made, or everything that I said in total, then it was seem to suggest that the initial statements about him being bad and beating the students up is not really defamatory, because he's doing that for the good of the kids. So another example here would be, so if B publishes a defamatory statement about C having an extramarital affair, B will be successful in raising the defense of justification if B can prove that C indeed engaged in adultery. Next, the other defense that can be raised by a defendant is the defense of fair comment. So for the defense of fair comment to succeed, the following elements will have to be satisfied by the defendant. The defamatory words must be comments as opposed to statements of fact. The comments must be based on facts proven to be true. The comments must be fair, and the comments must be of public interest. So when we say that fair, so what is fair? Fair does not necessarily mean to be reasonable. The comments can be exaggerated, but what is very important here is that the comments must be made in absence of any malice, and it must be held to be honest. So for example, let's say we say a company, let's say maybe, which I'm going to come to a case subsequently, there's something similar, but let's say, for example, I made a comment to say that this company, for example, the working environment is like earth coming down on me. So it's very exaggerating, but it could be fair because it's reasonable done, and I've been working there, so I know that the workload is terrible. Hence, I'm saying that working there is like the earth is coming down on me. Yes, so just to explain this point, comments can be exaggerated, but it must be held to be honest. So yes, the earth coming down on me can be an exaggeration, but it's honest, and there was absence of malice because while working in the company, I have a lot of work. So this is an example of fair does not mean to be reasonable, but it must be made in the absence of malice, and it must help to be honest. Next is whether a matter is such as to affect people at large so that they may be legitimately interested in or concerned at what is going on or what may happen to them or to others. Then it is a matter of public interest on which everyone is entitled to make fair comment. So this was stated in the case of Datuk Seri Dr. Muhammad Saleh Ismail against Nurul Izzah Anwar. So in this case, Nurul Izzah made a press conference alleging some impropriety on the National Feedlot Corporation. So in the press conference, some statements were made, or some alleged defamatory statements were made. Hence, the plaintiff filed a defamation suit against Nurul Izzah. And in this case, the High Court, the Court of Appeal, and also the Federal Court found that the defamatory statements cannot be read on its own. It has to be read in the whole context of the press conference. So the court held, like what I've said earlier, under the Section 6 of the Defamation Act, you have to read as a whole. So in this case, even for fair comment, you have to read it as a whole. And what Nurul Izzah did was, the comments she made was of public interest. Hence, the court dismissed the defamation claim. So again, for the defense of fair comment, it will fail if it was published with malice. Hence, if it's honest and without malice, then it can amount to a fair comment. So for example here, if it's said of a member of the bar that he is unfit to be a member of the bar, that statement itself is one of fact. On the other hand, if the same statement was prefaced by a statement that the member of the bar has been convicted of cheating, then the statement becomes a comment. So for example, the member of the bar have been convicted of cheating, and then I say that he's unfit to be a member of the bar, then that statement becomes a comment. So another case on fair comment is the one that I mentioned earlier on working in a company. So in G. Sundram Berhad against LMY, okay, so what happened in this case was the plaintiff sued the defendant, who is an ex-employee, for certain posts that was made by the defendant on this forum called the Laureate Forum. So the statements that were made by the defendant was in relation to the work environment and the conditions. And the statements exactly was, if you work for the money, don't go, not as promised. If you work for interest, don't think, you will not know why. If you work for every challenge, welcome, you will definitely feel like Warfield every day. So like what I've said just now, Warfield can be an exaggeration. And this was also exactly the point that was raised by the plaintiff in this case. And it was also an issue that was considered in this case by the learned judge. As you can see here at paragraph 24 of the decision, on the defendant's usage of the phrase Warfield, the defendant testified that the expression used by her was based on the high turnover in staff, CCTV monitoring movement of employees in the office premises, and rude and humiliating remarks of SP1. SP1 here was the managing director or the manager of the plaintiff's company. So the defendant explained on what she has experienced during her tenure with the plaintiff. So SP1 here is the witness, which is also the managing director, admitted that there was a high turnover rate in staff with over 50 to 70%. The defendant further testified on various practices of the SP1, which includes to having the merit book called the Purple Book, in which salary of the employee will be deducted for wrongdoing. In this case, what happened was there was also allegations that the SP1 requires the staff to eat some health boosting pills every day in order to prevent the staff or the employees from getting sick and able to work harder. So the judge made his findings, and it's my finding that the defendant evidence on this aspect of the Warfield was corroborated by the evidence of FD2, which is the defendant's a witness for the defendant, which is intern, and also by the independent evidence of commenters of the same forum, namely A, B, and C. So in this case, the defendant called another witness who is an intern to come and testify in court, which gave evidence that corroborated with what employee or defendant had said. And on top of that, there were also other evidence by commentators, which is A, B, and C, which happens to also past employees who happens to say similar experience or share similar experiences in regards to working in this plaintiff's company. Hence, the judge is of the considered opinion that the defendant's expression on the Warfield is qualified to be comments based on basic facts and her own true experience with the plaintiff's company, and in response to an inquiry by a member of the forum. Yeah, so in this case, the judge finds that it was fair comment, and the defendant was the defamation suit was dismissed. All right, that's all from me. I will pass the floor to Eric. Eric will continue with the online defamation.
Thank you, Gan. So yes, as Gan has given us a brief introduction on defamation, and he has talked about publication, which is a big part of online defamation, because when you put something online, it's presumed to be published to a lot of people because of the internet and social media. So, and the defenses that people usually rely on in terms of businesses and giving comments on businesses will be justification, which is whatever that I posted is true, and fair comment, which is I'm just commenting on, let's say, your service or your product. So people will usually say, okay, this is just a fair comment. So it is not, I shouldn't be liable for the defamation to pay any damages. So today I will go through a few online defamation cases and platforms on social media, which is Facebook and Twitter, and Google reviews, which is now a very common and widespread method of reviewing or giving comments on companies. So Twitter. So the case of Dato M and NAR, this was in 2012 at the High Court. So the plaintiff was a businessman and a managing director and shareholder of a group of companies. The defendant is a journalist. So in the course of the work, the defendant actually posted some comments about the plaintiff on Twitter. Now, in terms of publication, of course, the plaintiff argued that the defendant's Twitter account was public, so his comments were visible to everyone and not just his followers. So, and every time the defendant sends out a tweet, it will be sent to his followers in real time. So I'm sure, as everyone is aware how Twitter is, you tweet something, immediately a lot of people will be able to see it. So if you tweet something defamatory about someone or a business, a lot of people will be able to see it immediately. So the High Court, after going through all the evidence, said that aggravated damages can be awarded in light of the defendant's conduct in failing to make any apology. So the plaintiff actually asked the defendant to apologize, withdraw the statements, which is what we usually do when we commence, before we commence a claim against a defendant. We will say, apologize, withdraw the comments or pay damages, etc., etc. So in this situation, because the defendant failed to do anything, failed to apologize, failed to withdraw, and caused the whole suit to have to go all the way up to the hearing, the court said, your conduct means that I can pay aggravated damages. And court also said that the defendant is a journalist whose column garners a healthy following. The defendant's column regularly deals with issues of public interest, which invite discussions and thoughts among readers. And his Twitter website with more than 4,000 followers would naturally see heavy traffic. So the defendant's standing and his followers also played a big part, because when he tweets, a lot of people will see it. So this added to the amount of damages that the court thinks should be granted. So in the end, the court held that the journalist was liable for defamation, and the court awarded 300,000 for general damages and 200,000 for aggravated damages. So what other reliefs that you may see when someone tweets defamatory statements on Facebook? So this is a bit of a more unusual relief, which is back then in 2011, Fahmi Fazil was forced to apologize after saying his pregnant friend had been poorly treated by employers. So it was settled out of court, and one of the terms of settlement was that she is to apologize 100 times in the Twitter defamation case. So he has to tweet, I think, once every day. And he has to tweet this: I defamed Doing Media and Female Magazine. My tweets on the HR policies are untrue. I retract those words and hereby apologize. So he had to tweet this, I think, 100 times, and that was every day. So people can be very creative in how they want to achieve a settlement for defamation claims. So, you can do this. You can say, retweet it 100 times. You can say, if you are defamed on Facebook, you can ask the person to post something on their own Facebook to apologize to you, or you can ask them to apologize on your page, etc., etc. Or the more usual ones, maybe publish an advertisement on a newspaper to apologize or claim damages or withdraw their comments. So the possibilities are actually quite wide. Now we go to Facebook. So the case of GSRS and Bahad versus LKS 2018. So the plaintiff is a company carrying on a business as a real estate agent, among other things. The defendant was an ex-agent of the plaintiff. So there were, I think, a few statements made. The primary statements, the judge held that these allegations or these statements meant or were understood to mean that the plaintiff was a dishonorable company, had unreasonable policies, victimizes its agents, ill-treats its agents, and withhold commissions. So that was the primary statement. But how about the other posting by other people in his Facebook page? So the judge held, and this is somewhat similar to the Malaysia Kini case recently, as explained by Gan. So the judge held that it is clear beyond peradventure that the defendant was well aware of the secondary statements posted by third parties on his Facebook page and did not remove them. So he knew about it, he did not remove it. And the judge also held, in fact, the postings were specifically in response to the defendant's own postings. And in the end, said that it could be maintained that the defendant had caused publications by third parties. So just something to be aware of, to be cautious of. If you post something and you see other people replying to your statements, but they have said something defamatory there. So it may be the obligation on you to make sure that those are deleted or to clarify those so that you are not in trouble. You do not get in trouble for defamation, even though it is not you who posted it. Because your Facebook page, the court will say that you have control over what is stated in your Facebook page. So yes, the court held the defendant liable for publishing the secondary statements, which are not his postings, but other people's postings, because those statements also caused the reputation of the company to be reduced, portrayed the plaintiff as a dishonorable company. And the remedy given by the court, damages, again, aggravated damages, 50,000. Injunction to prevent the defendant from publishing further statements and to remove the statements from his Facebook page. For another case, this is regarding a restaurant, the case of ST Sendirian Berhad and LMJ. So basically, in this case, the plaintiff filed an application to file an injunction to restrain the defendant to publish comments on Facebook, which are allegedly defamatory of the restaurant, until the hearing and final disposal of the main suit. So it's an interim injunction, a temporary injunction. So what are the facts? The facts is that the Facebook posters were in relation to an alleged bad service in the restaurant by the plaintiff. And one of the posters by the reviewer or the commenter on Facebook was shared more than 9,000 times on Facebook and actually ended up in newspapers, websites, and blogs. And the plaintiff said that, because of all these, customers cancelled their reservations. And if the court does not grant an interim injunction or temporary injunction, the plaintiff will suffer more loss, irreparable loss to his and damage to his reputation, because no one will want to go there. And sometimes the defamation suits can last quite a while, maybe up to a year. So in the meantime, if injunction is not granted, then no one or less people will go to the restaurant, and of course they will suffer losses. Now, I just reproduced here some of the postings by the defendant. And in that case, she mentioned there was this conversation with someone in charge named Chieh. So basically, she was saying that she made a reservation. Why is she seated in somewhere that is not to her liking? Macam mamak chair, she says. And she said, your advertisement is not like that. And then she claimed, which turned out to be untrue, or it wasn't proven, at least at the time of this judgment, that Chieh said, you coming here for food only. If you want chair, you should go to IKEA. And then she says she felt cheated. And Chieh says, this is an advertisement, you cannot, basically saying that maybe the advertisements doesn't reflect the true nature of the place, and kind of saying that he's admitted that he cheated the customer and she wants a refund. She then, after that, the defendant also had another post. So first post, and then after that, there was another post by the defendant in Chinese. Very similar, but with these additional statements. They say, tetapi masih juga ada kawan internet yang lain amat marah dan beritahu saya bahawa mereka terpaksa tunggu dengan begitu lama baru dihidang makanan. Makanan juga sangat tak sedap, berbeza dari gambar. Mereka amat kecewa. Fikirlah, makan malam 210 untuk 2 orang, bukan murah sangat. Harga ini dan diatur duduk di tempat begitu, cara perkhidmatan teruk sangat. So that's what the defendant alleged and claimed. She said that these comments was based on comments from other internet users. So, she's saying, look, other people say it, so I'm just reposting it here because that's what I hear from other people, and not from her own experience dining at the restaurant. So what did the court say? What did the court think about this justification? Can she rely on the defense of justification? Is it substantially true what she said? But the court said the defendant failed to adduce any evidence to support her contention that the events and conversation between her and Chieh was as she has stated. So no proof given of the conversation even happening or the contents of the conversation. And in terms of the truth of the comments in the posting tool, they also failed to verify the truth of the comments from the other people who commented that the food was not good. So she cannot rely on justification. Talk about fair comment. Is it a fair comment for her to say all those things? Like the food was not good, etc., etc. But again, the court said, there was no evidence to show that her comments at the time were based on true facts. So if you recall, Gan was talking about what is a fair comment. A fair comment must be something that's based on true facts. So if the facts that you comment on is not even true, then it's not a fair comment. So for example, he said the member of the bar. So we are saying that the comment was the person is not fit to be a member of the bar. And why do I make the comment? It's because the person was convicted of cheating. So that is the facts that I'm relying on. The person is convicted of cheating. My comment is, so then of course the person is not fit to be a member of the bar. But in this case, the defendant can't even show that the food was not nice, or it was not even her own experience. So how can she make that comment? So the argument of fair comment will fail. Now I'll go quickly to Google reviews. So yes, Google reviews is now very popular. So this Google review was it's a case in Australia, whereby the plaintiff is a lawyer, and he receives referrals by word of mouth. And in late 2018, he became aware that he was losing clients. Okay, but normal. Sometimes you just lose clients. But he discovered that in February 2019, that a review was posted on Google My Business in English and Chinese. And so what was the review? The review said, "Stay clear of this place. She brings shame to all lawyers and is infamous for its lack of professionalism among the law society in Adelaide. He is concerned only about how to get your money and convincing you to go to court." Okay, not something that it's not uncommon. I think we've just seen these kind of comments, especially about lawyers. So by around February, 80% of the clients left. So the plaintiff lodged a complaint with Google. But then the defendant, either smartly or otherwise, so in the review, she put her name as L. So after the complaint was lodged, she changed her name to B. And after receiving a statement of claim from the plaintiff, changed her name from B to C. So to control the damage of the practice, the plaintiff posted a statement of claim on the website. And the review was finally deleted in April 2019 by Google. However, on 20th of April, the defendant then posted another review using her father's name. Bad lawyer, not at all reliable. But the problem is, the plaintiff or the lawyer never met the defendant. It was never her lawyer. So what did the court do? The court said, "Look, this is just a fake review, and it's defamatory." So the court granted 750,000 Aussie dollars to the lawyer, and these are the breakdown. All right, so tips and how to respond. So what should you do if you receive a bad comment or bad review or a negative review? So do not engage immediately, because what happens is, if you engage immediately, you may be in danger of defaming other people. So for example, if let's say you open a restaurant and suddenly immediately after you open a restaurant, or a couple of days after, you have some random person saying, "Oh, the restaurant is horrible, the food tasteless, it's dirty." And then you suspect there's actually a competitor who has posted that. So then you go and immediately reply, if it was on Facebook or if it was on Twitter, you immediately reply, "Oh, I know you. You are from XYZ restaurant. You posting this. So you are the ones who are serving bad food and having dirty environment." So if you do that, then XYZ restaurant can then come back and claim against you for defamation, because maybe it was XYZ restaurant, we don't know, but because you specifically name XYZ restaurant, then the XYZ restaurant can claim back against you for defamation. So importantly, I think, do not engage in the moment, in the heat of the moment. Cool down and think about how you want to respond. Maybe you check with a PR person, check with someone else to discuss your response. You can also ask the poster of the statement to remove, either on Facebook, Twitter, on your website, Instagram. Ask nicely, "Can you please remove it?" if you believe that it is a fake review or it's not a fair review of your services. Now, there is a distinction between bad negative reviews and fake reviews. So fake reviews are like the Google case. Bad negative reviews could be defended under either justification or fair comment, because maybe at the day your service or maybe your products really is actually that bad, or so it's either a fair comment or it's justified for the person to make that sort of review. So what happens if you receive that review? So you should check whether the reviewer was actually a client of you. Like for example, the Google case, the lawyer discovered that the person wasn't even actually the client. So So that's one. If the Google review, you found out that it's fake, request the reviewer to remove it, or if possible, contact Google to help you remove it. But yeah, Google takes time. So if reviewer refuses to remove or review the comments, or then maybe you can consider commenting a claim against the reviewer if you can find out who that person is. But of course, nowadays with internet, there's a lot of anonymous comments. So what can you do? If you don't know who said the fake comments about your business. So we have what we call a PreAction Discovery. This is one of the things you can do. In this case of KAP, Sdn Bhd, and MO. So the plaintiff is a franchise owner of cafe outlets. Defendant is a company dealing with activities related to payment. Second defendant is a company providing website registration services. And the third defendant is the owner of the website where the defamatory article was posted. So basically what happened was the plaintiff didn't know who was the author of the article, but he wanted to find out. They wanted to find out. So what happened was the plaintiff commenced the PreAction Discovery against the defendants because the defendants have the information about the website owners. So in turn, the website owners will have information on who is the author of the defamatory articles. So through this way, step by step, you can try to find out who was the actual writer or reviewer or commenter if it is not apparent to you from the comment. So what was the order? What were the orders sought by the plaintiffs, defendants to disclose information on the identities of the website owners, and for the website owners to then disclose the identity and addresses of the people who posted the defamatory content. Yes, it's a very roundabout way to do it, but sometimes if there is no other method for you to find out who was the person who gave those defamatory statements, then you have to do PreAction Discovery. Okay, I think time is running short, so we'll go to question and answers. Pass it back to Rachel.
Thank you, Eric and Gan, for your insights. We will now go to the question and answer session. So our first question is for Gan. Our first question is for Gan. So Gan, the first question is, what about statements posted on the Instagram or Facebook stories for closed friends instead of public posts, which will automatically disappear after 24 hours? Will the statement be deemed defamatory?
Okay. This question is about IG or Facebook stories to close friends, but I'm not sure to what extent the defamatory statements were made and how is it actually disclosed to a third party. Let's say, for example, even in the IG or Facebook stories, you make defamatory remarks against someone, let's say, for example, and even to close friends, and it will disappear even after 24 hours. Yes, the statement will still be defamatory if, let's say, the third party is able to capture or record that statements or whatever or the Facebook or IG stories that was posted. So even if after it disappeared within 24 hours, yes, it can still be defamatory statements made.
Thank you, Gan. Our next question is directed for Eric. Eric, so your question is, if an anonymous has posted a defamatory Google review, how can the business owner initiate legal action against the anonymous person? Should the company commence a legal action against Google to remove the comment and or disclose the identity of the anonymous person? Or can the company claim damages from both Google and the anonymous person?
Okay, thank you, Rachel. Thanks, Eunice, for that detailed question. So yes, as I mentioned earlier, so one way was to, how do you find out who is the anonymous person, right? So yes, if it's by Google, there are, I think, a couple of methods you can consider. Firstly, you can actually consider commencing a suit against Google, but that should be back in the US. So what you do is you commence a suit in the US against Google to disclose, to find out who is the reviewer. So, and there is a case, I think, in Malaysia that is very similar on this. So they did commence a suit. I think it was Facebook or Google, can't remember. So you can do that. And whether you can commence legal action against Google to remove the comments, or yes, you can. And can the company claim damages from Google and anonymous? Okay, so I think this is a practical exercise. So do you want to claim against Google for defamation and in the US, and then having to, even if you get a judgment sum, you're gonna have to enforce it back, then, trying to get the money. So do you want to do that? Or, do you want to find out who is the poster? If the poster is in Malaysia, for example, then maybe it's better and easier and more cost effective for you to commence a claim in Malaysia against that anonymous poster instead of having to, have a lengthy trial and in the US against Google. I hope that answers the question.
Thank you, Eric. Gan, the next question is for you. Would commenting on the incompetency of another party in a business setting constitute libel? If so, what would the best defense be, and how can I defend myself from a letter of demand?
Okay, to answer this question, I think we have to go back a bit on what I have discussed earlier or shared earlier. So, what is the whole purpose of commenting on somebody's incompetency? Whether it's their malice again. So, the issue of malice here will arise. Is it really? Can you rely on the defense of justification? Is it justified to make that kind of comment? And from this question, it seems that you are or wanting to do it on purpose. Then, if that is the case, there is some form of malice in it, and also it's not done with the honest intent. Hence, the next part of the question is: so what will be the best defense be? Technically, there is really no one-size-fits-all kind of answer, and it really depends on, at the end of the day, how do you comment, what do you comment, and what was the intention of making that whole comment. Hence, again, a very main point here will be justification. Can you justify or making the comment that they are incompetent? And also whether when you're making the comment, is it made out of bad faith, malice, or ill will to actually tarnish the other party's business? So I think it has to take into account all this as a whole to answer this question. I don't think it can be answered in a short answer way.
Thank you, Gan. Eric, the next question is for you. Must the plaintiff prove real damage?
Okay, so if you're talking about defamation libel, which means written defamation, so the law says that you don't have to, it is actionable per se. So there is no need to prove actual damages before you can succeed in a claim for libel, because the court can give you general damages based on your position and standing, the extent of the publication, the hurt or distress caused, and the conduct of the defendant. However, of course, if you are able to prove your damages, if you're a business, for example, so for the Google case, the lawyer case, so what happened was he actually engaged an accountant to prepare accounts and then presented to the court and said that, look, before these comments were made, I was earning this amount of money. And then after this comment was made, I clearly suffered a reduction of my clients or my income. So in that sense, if you can prove those damages, then you'll get more in that sense. You get better or more damages because you can prove what you have suffered. But if you're talking about whether you need to prove real damage before actually commencing a suit or needing it to succeed in a suit, then no, then the answer is no.
Thank you, Eric. Gan, would you like to take the next question?
Yes.
So if a Facebook account posted something defamatory in a group, for example, ABC Blow Water Station, to what extent do the administrators need to be responsible?
I just don't quite get what it means by ABC Blow Water Station. Eric, maybe you...
Yeah, okay. So I think ABC Blow Water Station is like an English translation of a Chinese Chieh Sui Zhan. I think I've seen those Facebook groups on Facebook. So to what extent do the administrators need to be responsible? Okay, so I think if you look back at Malaysia Kini's case and another case that I mentioned about the Facebook page, so it really depends on the control and to what extent can you control the comments made. Are you even aware of the comments? So if it was brought to attention, what have you done to make sure it's removed? So if someone already told you that, oh, this is defamatory, if let's say you defame a business in that page or in that group, and then you don't do anything about it, then it's more likely that the administrators may be found to be responsible because they are in control of the page itself. Yeah, I think that's the answer.
Thank you, Eric. I think the next question is slightly relevant. So, Eric, I think you can take this question as well.
I think I can take the one from Wati Junis.
Okay.
I want to refer back to the 24-hour IG and Facebook stories. So yes, how do you remove from Facebook? If you are the one that posted the comment, then of course I think you can remove it. But if let's say you are the let's say you're the defendant or being defamed, then the other way is to write to Facebook to have it removed. So can one still be sued if you have removed the defamatory statement on Facebook? Yes, of course you can, like what I said about the IG and Facebook. Yes, if you have managed to capture the capture screen of what was actually posted on Facebook or even IG, and even if after it was removed, yes, you can still bring in a defamation claim. But it's relevant, the removal is relevant in terms of damages to be awarded by the court. The longer the defamatory statement or remarks are posted online, the more damages the court will actually award. Yes, so that is something that the court will consider when it comes to awarding damages if defamation has been proven. That's all. Yeah.
Thank you for your answer, Gan. So the next question, I think Eric, you can take this one. So what is an effective way to trace a person's true identity who uses an anonymous account online?
Yeah, so similar to what I've mentioned before. So the best way, I think, is to go to court and get a discovery order against either the website owner or the maybe your local service provider, the network service provider, and then maybe get the IP address of the person and then trace the person's identity. So for example, maybe if someone post something online using internet data, so one of the either DG, Maxis, Celcom, whatever. So perhaps you can file a claim against DG, Maxis, Celcom to find out who is the holder of that number or the account or the number they used to surf the web. So then you can actually through there find out who you might want to claim against. So that's one example. Another example is, again, you file a suit, find out who's the owner of the website. The website owner will have to disclose who is the person who published the anonymous post.
Thank you, Eric. Our next question is, bad review for surveys where it is to remain confidential is not defamation, right? Gan, would you like to take this question?
I can take this. Again, in a general setting, of course, this kind of surveys, it really depends on what kind of surveys. Let's say, for example, you have a survey company trying to ask you for, maybe they are marketing a new product for an established company. So they may ask you for certain questions. In a general setting, yes, such corresponding statements are to be remain confidential. But again, I think everyone has to bear in mind, it must be made without malice. We wouldn't know what will happen to these surveys. And let's say it happens that it falls to some third parties. For example, let's say for some unsavory remarks have been made. So again, let's say they decide to bring an action, then again, they will fall back again to all these defenses. Whether is there a privilege? Is there a qualified privilege, or is it justified? Is it a fair comment? So again, if it's made with malice, with the intention of hurting the reputation of the company per se, then it will be defamatory.
Thank you, Gan.
Now, Rachel, I can take the next question.
Okay.
Okay. Is pre-action discovery and interlocutory application, does it need to be preceded with a main suit? No, pre-action discovery is not an interlock because you do not have an existing suit. So what you should do is file in an OS to basically get what documents you want from certain companies or certain people, or maybe even, let's say, you decide to go again, Laureate Forum, for example, you need to have certain information or particulars that you need from these companies. Yes, then you will file in a pre-action discovery. So upon obtaining these documents or information, then you will decide whether do you really have a case to actually proceed. Yeah.
Thank you, Gan. Our next question is, if comments is within a private group chat, is there any element of defamation? Eric, would you like to take this one?
Sure. So, okay. So we look back at what are the elements of defamation, right? So defamation, the statement must lower the estimation of the person to third parties. It must be published, right? So the important element here is publishing. So yes, it's a comment within a private group chat. So but it's still published. So for example, if I have a WhatsApp group with Rachel and another colleague, and there I talk bad about Gan, right? So, and that will cause his reputation to be reduced, unless it's justified, of course. So there will be elements of defamation. So there it matters of whether there's any defense, justification, or is it a fair comment, or actually, if you look into damages, the court will see how many people are actually in that group chat. So, private group chats can be 3 people, can be 5 people, but it can be a big amount, 50 people or so. For example, if it's a resident association kind of group chat, it's private, but it has a lot of people. So even though it's not doesn't matter if it's a private or public account in that sense, it's just a matter of if as long as it's published to a third party, it could constitute defamation.
Thank you, Eric. So we will now take the final two questions. So the next question is, will the court consider if the plaintiff has been convicted of hiring illegal workers? The plaintiff is suing for Malaysian ringgit 1 million.
Okay, it really depends what is the context. Yeah, what is the context here you are talking about? If let's say the statement has been made in respect of him hiring illegal workers, which is justified, then of course it's not defamatory. But if he has been convicted of hiring illegal workers, but the defamatory statements here is made about his extramarital affairs, then to me, that doesn't gel. That will not, him hiring illegal workers has no effect on you making a statement of his extramarital affairs. So yes, it really depends on the context, and not just because he has been convicted under the law for a particular offense, we can just make a blanket statement or defamatory statement for everything under the sun.
Thank you, Gan.
Yeah, Rachel, I'll take another one. So the next question is, what's the time limit for instituting legal action for defamation? The law states that it's 6 years from the date the publication of the defamatory remarks.
I think there's one last question which I overlooked, which was posted in the chat box. So in what event a buyer's negative comment on an online shopping platform will constitute defamation? Eric, would you like to take this question?
Yeah. So, well, again, this is the distinction between a negative review versus a fake review, right? So if the negative comment, again, it depends on what is said in the negative comment. If it's indeed true that, let's say you sell phones, and then whatever, and then the person said, wow, the phone when it came to me is already spoiled, it cannot turn on, display, there's problems in the display, then of course there's a defense there, justification, because it is a true comment. Just that it is negative because it is true that the product is actually bad, right? So that is the negative part of it. However, if it's a fake comment, if you realize that the person never bought a phone from you, and you discover that you check your client list lah. That's why I say one thing you must do is you check your client, who you sold to, and then you found out, I never sent to this person. Who is this? Then that is defamation in the sense that there's no defense there because it is a fake review, a fake comment.
Thank you, Eric. So thank you, Mr. Gan Chong Chieh and Mr. Eric To, for your insights. Before we conclude, I have a few announcements to make. First, please join us again for our upcoming talk on the 1st of September 2021. The topic of the talk is, Am I a tax resident in Malaysia? And it will be presented by our Miss Christine To. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat box now. Thirdly, please follow or like our social media accounts. We are on YouTube, Twitter, Instagram, LinkedIn, and Facebook. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website. The link is also posted in the chat box. So finally, thank you everybody for spending a little over an hour with us today for this talk. And I would like to see you at our next talk. Have a good day, everybody.
Yes, thank you, everyone.
Thanks, everyone. Stay safe.